Alright. I think all gremlins are chased away and we are ready to go. Alright, we're either back on or just on. September 17th, and we had some issues with our civil protection order recording stuff. Alright, so I've taken roll, I know who's here, and I just want to take some things that I think will be a little quicker than others. And that, I think, is going to begin with Trelana Fletcher. If you would come forward, please. Good morning, or good afternoon. You just have a seat at the table right there. This is Civil Protection Order 25-198. And this is Miss Fletcher versus Shannon Loomis. Shannon Loomis present. Shannon Loomis is not present in the courtroom, not present on Zoom either. And I'll say it's not a surprise to the court because what I don't see in here is service. And so just for information for you, if a person hasn't been given notice of this hearing, we can't necessarily move forward with the hearing. And not seeing service in here when I was reviewing the files earlier today and them not answering led me to believe that this was going to be a little quicker type of hearing because I have no options except to move it down the road a little bit.
Yes.
So it sounds like you are aware that there is no service on Shannon Loomis at this particular point.
Correct.
It is also the court's, it's our obligation to do it, or to at least turn it over to law enforcement to do it. However, then we become subject to resources that they have for that. And the rules require that the person be given at least 7 days notice of the hearing. And so when I reset these, I have two questions for you. First of all, since you filed the petition, has there been any additional contact that's unwanted?
Well, yes.
Okay. I can't use that against them in terms of they don't have notice of the petition in the first place, but just so that so what I'd like to do would be to get this, since there has been some contact that's been unwanted, I want to get it set up as quick as we can, but I don't want to set us up in a position where we don't have enough time to between service and the court hearing. Does that make sense to you?
Yes.
Figure about 2 weeks hopefully is enough time for the remainder of this week, and then all of to get served, and then preparation, if you will, would be all of next week, and then be back before the court again on temporary order. Yeah, full hearing to be held. Okay, so you were actually agreed or told to make private arrangements, so that's why you know that you don't have service.
Well, yeah, I just found out the other day when I picked up my documents.
Okay.
And nobody informed me that
Okay.
it was denied, which I guess.
Well, the temporary was denied, but you were granted a hearing, a full hearing. Either way, there needs to be notice, and so, oh, I see. So the judicial officer checked that it was required that the restrained person must be served with this order, and I don't know if it was intentional or not, but there's another X indicating service by yourself, and usually there would be so I don't see a note in here as to why that judicial officer did that, because there isn't anything in my reviewing it that would indicate that that was sort of your choice. So I guess, alright, so I'm going to change that. I don't see anything about your petition that would cause it to have to be,
I'm wondering if it
or
maybe
the
has to do
burden
with the director.
bore by you. Is that?
I don't know, maybe it's not
Maybe
just
was
like-
it an address issue?
let's see.
Sometimes if the court doesn't have a good address, and it appears that the petitioner does, sometimes we'll defer to them. But either way,
Yeah, they were missing the.
while we're looking at that, so we've got, what do you got for now? You got a Champion Street there.
Is it 308? I can't really read that.
Okay, well, we have an address, so tell you what, let's just start looking at what works. 2 weeks to the Wednesday, a good day for you?
Sure.
Okay, we do these hearings every Tuesday, Wednesdays, and Thursdays. Judge Anderson hears them on Tuesdays, I hear them on Wednesdays, and then Commissioner Parise hears them on Thursdays. Since I've got it at this particular point, and I might as well keep it. What do I have in 2 weeks? What's that calendar look like, Miss Mary? It would be September. It would be October 1.
Nothing.
All right. There's nothing on the calendar right now. I like to keep these to no more than 3, so you'll be number 1, and I will indicate that law enforcement is going to serve this for us. So that is 10-1. That'll be at 3 p.m. So, Miss Mary, we'll get the new orders. New order has the box fixed. Great. Law enforcement agency will serve it, and that'll be Bellingham PD. Personal search by law enforcement is required because. Do we have an email address as well? In the LEOs.
Yes.
All right. I've just checked the box that law enforcement will serve this. So they'll serve not only this new date and time, but they will serve the original package to the person as well. So that would give them the notice. All I need is a signature from you on this last page. I already put your name in there, and the date's already there, so just give me a signature next to the X right there. And what you're signing for is receipt, because I'm going to make you a copy of that, and then you will be free to go, and I will see you in 2 weeks.
And then my question is, I had a couple of questions, so when I could submit.
You can submit those documents here if you like. We can file them in open court and put them in the record. If that's what your intention is for, okay?
Thank you very much.
You betcha. Wait one, and I gotta give me a stamp on that too, please, Miss Mary. And then we'll make a copy, and then you'll be free to go. Hang tight here for a moment. Save you a trip up.
Oh. Only for them, copy it, okay.
Here's the list, correct?
10/1/2025, 3 p.m. There, date and time on it.
Thank you very much.
You're welcome. Take care.
Have a good day.
So I'll just file the note for that materials. All right, let's next take the matter. Danielle Carlson, CPO 25-199. Good afternoon. How are you? All right. This is a matter where a temporary protection order petition was filed and a temporary order was granted. And a service of process has been accomplished. I am looking at proof of service by a law enforcement officer on 9/3/2025. That is within the appropriate time frame, and there's no indication that they were not served. They were served at 15:30. So the next step of this, or this phase, would be find out if there was something additional you wanted the court to know above and beyond the material that you've already submitted in writing, which was sufficient to get a temporary order. But most importantly, I am curious if there has been any unwanted contact since the person was served with this temporary order, and they were served on September 3rd, 2025.
No, there has not been.
That usually, if there is, that, for lack of a better word, that usually seals the deal, if you will. So again, in this particular case, I have reviewed this, and curious if you would like to provide any additional information above and beyond that which you have already provided to the court. Anything that you wanted me to know further?
Unless you want to listen to the message itself, since it was a voice recording, I am able to play that on my phone, if that's doable.
We can't yet, we can do that, but at the same time, you submitted the documents under penalty of perjury, and I assume the message is what you said the message is.
Yeah.
And so, I guess what I'm telling you is, I don't need anything additional other than what you've submitted. It is, the judicial officer has already found
Okay.
that it was sufficient for a temporary, and you met that hurdle, and it was immediate and necessary. And if there was additional contact, that would certainly not go, would not go so well for the respondent, if you will. The only thing that I would note here is that the court was unable to access police reports or evidence. You would need to bring that evidence to court, which I imagine is why you brought that voice record. But we don't really know everything that you want to do when we do these. But when an order has already been satisfied, or you've already cleared that hurdle, and a temporary has been issued, generally speaking, and the person chooses not to show up, it somewhat goes uncontested, if you will. So my question to you is, I am prepared to grant you to convert the temporary into, I'm not going to say permanent because they do have time frames, but generally speaking, we start off on 1 year. Now, this is a harassment petition, which ultimately alluded to, or was quite clearly, threats to kill. And I think that your request initially was for as long as possible. And I don't necessarily want to start off on just 1 year, but don't want to say forever either, because the goal is that the person would get notice of this, and that it would do its job for however long it was, and you ultimately always have the right to renew these if you come before the court in the right period of time. But I also am recognizing that there is a significant amount of trauma that can be inflicted in terms of preparing for these things and living with these kinds of hearings coming up and things of that nature. So I'll ask you, if not just for 1 year, but also not forever, what do you think would be a good starting point? You are aware of this person and their behavior leading up to this better than the court is, and what would you think would be a good starting point, and potentially be a long enough period of time that it would become a habit and they would just leave you alone forever?
Well, the last time I had contact with him, Your Honor, was in 2020, about 5 years ago, so I don't understand why the contact came 5 years later.
Right.
I'm not sure if it's possible to do 5 years at a start.
I can do 5.
Okay.
I was thinking 36, but if you think,
Oh, okay.
but 5 at the same time, it makes sense in terms of.
Okay. I mean, if I can do 10, just to put it off there.
I prefer to renew.
Okay. 5 is okay with me.
If 5 is really the period of time where, on its own, there was no contact, and then that seems to be a magic number, if you will, for them to feel free. We'll do 5, and then if you read the statute carefully, it just means this: as long as you come back, I think it's within 90 days of the 5-year expiration date, and you ask the court to extend it, the burden would be on the respondent to prove why the renewal would not be necessary. Because the assumption is the order is doing its job, and so the court, the law is set up such that we renew them simply because you ask, and they have to prove otherwise. So with that knowledge, 5 years be okay for you?
Yes.
Okay.
Thank you, Your Honor.
All right, you are welcome. So, check that in 5 years plus 20, so that's going to be 9, 17, 20, 20, 2030.
Yes.
It's 2025 now. Whenever I talk about 2020 and stuff like that, I think of Buck Rogers. That makes me old. Alright, it protects you, and there's no children involved, right?
No.
So themselves. And it was personal service. It did have actual notice. Protected person did show up in person. Or relationship, if you will. There's a section on here in terms of really how do you know each other? And I see that you wrote a few things there, but I'm gonna do acquaintances.
That's okay.
Doesn't make you friends, doesn't make you strangers, but I think it covers what you're after. I understand the nature of the threats that were made under the statute. Those kinds of threats really do need, in order for me to find a credible threat and therefore order removal of weapons, I need to make a specific finding about the time that the threat was made, and I'm just not in a position to do that. So I'll tell you this, I'm not finding their credible threat. It doesn't change anything about the order I'm granting. It just means I don't have the authority to order them to surrender any weapons that they may or may not have. But just wanted to put that in context for you, okay? So I'm not checking credible threat, I am checking no harm, and as I do this, I'm just going along so I don't have to read the whole order to you as I go. I have checked the box, granting the order. It's going to be from until 9/17/2030. It does protect the petitioner themselves. I did make the findings that there was personal service and the restrained person did have actual notice, and the court did. We held the hearing, but they chose not to be here, so the hearing was held. You appeared in person, and you know each other by acquaintances. The other pages don't apply. Then we get to page 5 of 13. This restrained person has been subjected to, the restrained person has subjected the protected person to unlawful harassment, and I've checked that box, and as a result, the court orders general restraints. Subsection A, no harm, do not cause any physical harm, bodily injury, assault, non-consensual sexual conduct, or non-consensual sexual penetration. Do not harass, threaten, or stalk the protected person. That should, every time you hear the word protected person, that's going to be you, okay? B, no contact, do not attempt or have any contact, including non-physical contact, directly, indirectly, or through third parties, regardless of whether those third parties know of the order, except for service of the court documents with the protected person. Stalking behavior under section C, do not harass, follow, monitor, keep under physical or electronic surveillance by cyber harass as defined in RCW 9890.120, or use phone, video, audio, or other electronic means to record, photograph, or track locations or communication, including digital wire or electronic communications of the protected person. And by the way, they will get a copy of all of this as well, as will you. Subsection D, exclude and stay away, do not enter, return to, knowingly come within, or knowingly remain within 1,000 feet or other distance unless specified here. I don't find a need to lessen that distance or make that any greater, so knowingly come within or remain within 1,000 feet of the protected person's school, the protected person's residence, protected person's vehicle, workplace, and I don't think adult daycare program would qualify, a shared residence, or the residence, daycare, or school of minors, because there's none involved. And intimate images, I always check this one. I never really know. We never really know who has what kind of pictures, although you would certainly hope that you would know if there's intimate images. But either way, do not possess or distribute intimate images of the protected person as defined by statute 9A86010. The restrained person must take down and delete all intimate images and recordings of a protected person in the restrained person's possession or control, and cease any and all disclosure of those images. The other sections don't apply, so I'm just flipping over the pages until we get to the last sections here. And that last section here is section 11, service on the restrained person. It is required the restrained person must be served with a copy of this order, and the law enforcement agency where the restrained person lives can serve, and that is Ferndale Police Department. And personal service is required because it is. Actually, you know what? I'm gonna check the box that it's not required because we have a temporary issue. And the order says this: the restrained person did not appear at the hearing. However, the material terms of this order have not changed from the temporary protection order that was served on the restrained person. No further service is required. So,
Does the temporary have a date on it? Does it have an ending date?
doesn't have a temporary, but it's not required, but I am going to do email service.
Okay.
But the temporary order tells the person that, tells them clearly that if they choose not to show up, it very well might be issued, and that's why notice isn't necessarily required.
We don't have an email address for him.
No email? Okay.
No.
Actually, I'm gonna make it, yeah. I suppose you can just print me a new page 11, could you, Mary?
Yeah. The order of the.
Just a page 11 of the order.
Is that the one that starts with Washington County Information Center?
Page 11.
Is it
At the
the-
bottom, it should say 11 or 13. Just keep scrolling down. There you go.
Yeah, okay.
Yeah. So just right click that, and actually, I think you gotta go to File, and then just do Current Page under Print. So click it again. Print. Current Page.
Okay, ready?
Would you come forward and give me a signature at the X while I fix this by not having a messy order? The only thing that needed to be added on this with the boxes, Mary, was Ferndale PD, so I wrote that in.
Okay.
And whited out the
Okay,
word
perfect.
into, everything else I think is. I'm not even gonna say why it's required, it just is, because I ordered it. And that's page 11 and 13. That's 12, that's that, okay. Miss Mary, if you would please give me a stamp on that. Alright, I've read the order as it applies into the record. I'll give you a copy of it here in a moment. You have signed it, the last page, you're signing a receipt of it, but I recognize you're gonna get that in a moment here. Do you have any questions?
Thank you, Your Honor.
Alright, you're welcome. Alright, just one piece of information. This order is an order, it's a piece of paper, it's a signature. If the order is violated, you're the only one that knows if and when that happens, and so, you've taken the time, you've written the petition, you've come to court, you've spent some time. If the order is violated, take the time to call and notify law enforcement that you believe the order was violated, let them come out and show up. If you don't do those things, the order isn't valuable. Does that make sense to you?
Yeah.
I do have one question.
Sure,
I
I'll
know-
answer it if I can.
I no longer have to carry this protection order since I have this new one.
I mean, the,
Anti-harassment, that's what I mean. Yeah.
what we have is, so they're already in possession of the
Yeah.
temporary order. And it says very clearly in the materials that they received that if they don't show up, the order could very well become permanent and ultimately, if you have contact with them and they don't have the final one here yet, the fact that they didn't show up isn't necessarily gonna help them defend, well, I didn't know, because the order already clearly says that. Does that make sense to you?
Perfect, thank you.
Alright,
Appreciate it.
good luck, take care. Alrighty, and the last matter I have is Mr. Epic, good afternoon, CPO 25-182, and Jesse versus Jesse Polsowit is also known as Jesse Williams, is that correct, sir?
Oh,
Opposite way around? Okay.
I'm legally Williams, born Postaway.
Okay, that was a question that I had here. So I set this hearing because the hearing came, it went, I granted the order. I also issued, based on the materials that I heard and listened to and reviewed, I also issued a order to surrender weapons. However, there was an inability to serve you of the order and that declaration for some time. And I think there was 2 attempts, law enforcement notified us back. And so out of abundance of caution for all the parties, and for Mr. Epic and also for yourself, sir, I set this hearing some time ago to inform Mr. Epic that we were unable to serve you. And then we found you. You were found in custody in the jail under the name Williams. And so and you also signed off on a declaration of no weapons to surrender.
Yeah.
So we've achieved all of that, but it sort of happened backwards, because the whole point of setting the hearing for Mr. Epic, or notifying Mr. Epic, was that I planned on telling Mr. Epic, haven't been able to find you, but he was entitled to serve those paperwork on his own, and didn't have to necessarily rely on us. But so now that's sort of cleared the way. But now it's come to the attention that you have 2 names, if you will, and so I think what I need to do is clarify a couple of things. Mr. Williams was served the order regarding essentially the no contact order and the proof of surrender, and received both and executed a declaration of no weapons to surrender, but signed off on it under the name of Jesse Williams. And so, just for clarification, your true name is Jesse Dean Williams?
Yes, sir.
All right, and also known as, or have previously gone by, Jesse Polsowit.
Yes, sir.
Okay. So I think what I have to do is amend the order, amend the first page of the order. And I just wanted to make sure that, I mean, I could ask you for consent to do that, but at the same time, I want to make sure that you are one and the same. And so what I intend on doing is accepting the surrender of weapons, and I'll accept the surrender of weapons, or the non-surrender, no weapons to surrender, in the name of Williams, but also refer back to that you're also known as Jesse Postlewaite. And I think what we'll end up doing is send something over to the jail through intercommunications when the court modifies that order.
Yeah.
Okay. Do you know how long you're going to be in custody for?
No, because
Okay.
I have some stuff to deal with in district court probation.
Okay. All right. All right.
I'll be here for a minute. So
Okay.
I'd rather just try to take care of everything anyways and have it be behind me, so.
Understood. Okay. Well, all right. So that
I'd
was
like to contest all of this, first of all, so,
This-
when we get to that.
okay. Well, right now, I can't give you legal advice on that. I
Yeah.
can appreciate the jail bringing you over because the jail learned of the hearing. I'm not quite. I think you probably run either way. You brought him over.
Really,
Um,
I have no idea.
And so we've achieved what I needed to achieve, which was confirming that you were one and the same, and I'm going to direct my legal assistant, my clerk, to create just an amended cover page as to the name that the order is in.
Absolutely.
Okay. And then as to any sort of appeal or things of that nature that you want with this, I can't give you legal advice on that, but I'll encourage you to have a look at the rules or visit the law library or do whatever it is you think you might need to do in order to follow up on those things.
I need to know how to actually file one for myself, because I've been stalked by this man, harassed by this man multiple times, so I need to know how to do all those.
And I can't tell you any of those things.
Okay.
All I can tell you is achieve this goal and be on the lookout for a new service of just an amended order on the front sheet is what it's going to be. Okay? All
Okay,
right.
so while I'm in custody, it's just more of a challenge.
I understand that. It's also a challenge. I can't give you legal advice.
Yes.
I can no more give you legal advice if you walked in that door and sat here and said, how do I do this versus I'm in custody, how do I do it? Okay?
Your Honor,
Yes. Oh, okay.
she just sent it over. Is that
That's fine, but I need more pages, so we'll send it over and get a signature on it.
okay?
It-
We'll need some additional stuff.
All right, so that completes our business here today for this particular matter. Thank you for bringing them over.
So, when I get out, we don't know what direction I can go to take care of the same thing, because he's the type of man that will put a restraining order on and come back and harass and harass and harass and harass.
I simply-
And
I
lies
can't
and
answer that
stories
question.
and does a lot with the whole community.
If I was in a different position than a judge, I'd be able to answer that question for you, but I can't, sir.
Okay. So I'll just find out how I can also do the same thing he's doing. And
I think you can find out all of the things all of the responses that you can possibly have by consulting the rules or going to the court's webpage if you've got access to the internet and things of that nature. You can.
yeah, we have a tablet in there.
Yeah, if you've got
I
access.
just want to make sure to have it, because I know how it works. If I have a restraining order, I don't have any contact with him, but he can have all the contact he wants with me and not get a slap on the hand for nothing.
What
And he loves that,
there can be ways that an order can be
because
used.
he's not so bad.
Let's just say offensively, but at the same time, again, take the time to have a look at the rules, and it sounds like you got access to the internet, and that's about as much as I can say. Go
Yep.
there, look that, do some research, and you can do all of those things while you're in custody as well.
Yeah, well, thank
Okay,
you.
all right, you bet.
Have a good day, sir.
You as well.
Thank you.
All right, so I've achieved the purpose of that, Mr. Epic. I think you heard why I did everything that I did and why I had you come here. I do have some questions for you because I don't think that this hearing is quite over yet. And so if you'd like to come forward, I did want to ask you a couple of questions about some filings in this particular case. So this is CPO 25-182. So, sir, as you well know, we had trouble finding him, and so as a courtesy, I gave you notice of this hearing, and my intention was at this time to tell you we haven't been able to find him, but you're certainly able to serve him if you would like to do so. And that was something that I thought was important. You came before the court, you exercised your access to counsel, and I granted you that hearing, and I take them very seriously. And so, you not knowing that he had been served or a weapon surrender was important to the court to relay to you. And in response to that hearing, you started filing some documents under this particular cause number, referencing another cause number as well. And I guess my question is to you, why did you file the documents that you filed when there wasn't any need to do so? Because this hearing was really just for the court to give you a courtesy piece of information. And what you filed in two separate filings in this particular case was information regarding another hearing that involved Commissioner Parise. At least most recently, the court received some pleadings on 9/16/2025, but before that, served some materials to not only my attention as presiding judge, but also, as I saw it, my attention, District Court, Civil Division, Washington State Commission on Judicial Conduct, and I think a list of other agencies, actually a list of other agencies in the other case. And with the material, and the other case was cause number there we go. So it appears that you have a couple other matters, CPO 23135, CPO 24126, CPO 25-182. And those were matters that I know involved Commissioner Parise. And attached to those other matters were, let's just say, some documents, pictures, photographs that are completely inappropriate for filing into an open court record. So I guess, first and foremost, Mr. Epic, why'd you do that in this particular case? Why would you mix the two cases in terms of, and not only that, but why mix the two cases and then also involve a ton of other public agencies where now we have, I think by last count, at least 10 other agencies that have information that is not related to them in any way, shape, or form. Also, I'd note, I think there was a couple of email follow-ups as well regarding freedom of information that involved materials, and just to be completely blunt, the materials of that are pictures and the whereabouts of not a judicial officer, but a judicial officer's children.
First and foremost, Your Honor, I would like to say that I am Larry Epic and I am appearing today in a special appearance for the record.
He needs to come closer to get the
Hey, Mr. Epic, I need you to come a little closer. If not seated at council table, close enough that the microphone can catch you up.
So I have with me, Your Honor, with your permission, I have prepared a brief oral statement for the record.
Regarding what?
Outlining the crucial due process facts and evidence.
Okay, hang on a second. Your case with me under this cause number, it was granted and it was done and it's tied up in a bow and you have your order and the restrained party has all of the information that they need so that if there's violations, you're protected. My questions to you is, why did you file what you filed after that order in response to a courtesy notification to you?
Well, to answer your question, Your Honor, why I filed what I filed was because of the prejudice that was taken in relation to this matter. Jesse Postlethwaite, Your Honor, is in direct relation to the last matter with Commissioner Parise.
Hang on one second.
Which you have exhibits up there.
I granted your order though.
Okay.
I granted your motion.
So I was challenging, and then the evidence has been redacted, Your Honor. I have the right to face my accusers, and there was online slander in regards to that particular.
Not in this case,
This is in direct relation, Your Honor.
no, not in this case.
Okay,
In the cause number that you're here on today, and that I'm talking about, you rightly used the court procedure, you petitioned, you provided the information, you served, you showed up at the hearing, the respondent did not show up. I carefully reviewed all the materials that you submitted, and I granted your hearing. I granted your request.
Okay.
And I went one step further, and I ordered him to not have guns. I did everything that you asked me to do in that petition because you satisfied the rules. And in response to me giving a courtesy hearing to let you know that we were doing everything we could to serve him, and we ultimately did get him served, you filed additional materials in this case, but also additional materials referencing another case. So my question is, why did you file additional materials? That's just question number one. Why file additional materials when there wasn't anything being asked of you?
Again, because there was the online slander and the service that was not done properly for the other case.
Okay,
Right?
Okay.
Which I challenged the court. They extended a protection order against me after it was expired. I challenged the commissioner.
in the other case, right?
Yes, Your
Okay.
Honor.
Okay,
Yep.
so I get that stuff happened in the other case. Why file it in this case? They're not
Because-
related.
Well, it is directly related.
They're not
He's the
related.
same, well, okay, the same
Different,
parties.
different judicial officer, different set of facts, same respondent.
And when you granted, in my favor, the protection orders and my mother's favor, that particular day, shortly after, more stalking and harassment has occurred. Again, that was, filed in direct relation to the conflict of interest. You say that there's material facts with the judicial officer. I provided substantial evidence of the, conflict of interest, Your
Okay, so
Honor.
let me stop you there for a moment. Here's what I'm hearing. You were, for lack of a better word, either not satisfied or your hearings in front of Commissioner Parise were not granted in your favor.
And I brought this up to you.
Hang on a second, I know. But I'm trying to figure something out here, Mr. Epic, and so, because you're an intelligent man, you know the rules, you had your dictionary here with me before. What I'm trying to figure out is why you're not following the rules.
I don't understand.
Okay.
What you mean by not following
All
the
right.
rules.
Well, there's a particular, so in the cases that you submitted, the cause numbers that you submitted information under, as well as this one, the cases involving Commissioner Parise, for lack of a better word, I think what happened was is you were not granted the orders. You feel that there's a particular reason that you weren't granted the orders other than the facts. And what I'm telling you is there's a very specific way under the rules to challenge those rulings. And the way that you've gone about it is outside of those rules. If that's what you're trying to achieve, if you're trying to achieve an appeal, which is your right to do under these hearings, then you got to follow the rules. And you don't follow the rules that you think are in effect. You would follow the rules that this court operates under, which are found in this book or online for Court of Limited Jurisdictions. You would also follow the appeal rules for those types of things. What you do not do is scream from the rooftops, that's my analogy, and put a bunch of information into public records up and down the I-5 corridor from here to Seattle with Procedural, Woolies, Department of Justice and things of that nature about particular sensitive information or even public information about judicial officers' children, where they work, things of that nature. Now, and if your goal is to simply show that there's a conflict,
Which I did.
there is a way to go about it within the rules.
And
But first and foremost, it sounds to me as though your desire was to appeal those decisions.
the first time,
You
yes.
have to follow the rules. What you have done is not follow the rules, and I don't know if you're within time or not within time, but if you choose to follow those rules and be heard, You need to follow the rules and do it timely, and only file that material which is necessary. Because let me tell you what it looks like as presiding, as other presiding judges, as law enforcement that might be looking into this. It looks a lot like judicial intimidation, Mr. Epic. And it looks that way because it is not appropriate to put into the record judicial officers' public information, whether you know it or don't know it, but more importantly, information about judicial officers' family members, whether they're children, whether they're husbands, whether they're wives, whether they're cousins. That is just not the way to go about an appeal or to show your dissatisfaction with that. The way you've gone about it looks very, 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 very much like judicial intimidation. And if what your goal is to never have a case that you might file in the future in front of Commissioner Parise again, then that is a very simple filing of one piece of paper when you file your documents initially that simply says, I don't want Commissioner Parise to hear this case. Okay. So what I'm trying to nicely tell you, or not give legal advice, but tell you, the filings that you filed both in this case and then when I cross-reference and have a look at them, they're inappropriate, they're not proper, and if you keep it up, you very well might find yourself in some significant trouble.
Yeah, so can I ask you a question?
You can ask me whatever question you want, whether I can answer it or not.
So have you had the opportunity to review those filings?
I have had the opportunity to review the filings insofar as the fact that you forced me to review them based upon the things that you filed in both and cross-referenced each of them. I am not in the habit, and it's not the way this court works, unlike Superior Court, where commissioner decisions on civil protection proceedings are ever reviewed by a judicial officer.
So
There's
was
a
there any
distinct.
constitutional violations that you noticed in those filings,
I
Your Honor?
I was not looking at it in any way, shape, or form other than to
That was the purpose
look.
of me filing that, Your Honor.
And that is something appropriately done for an appeal.
And that's what I had done, and Your
But-
Honor, I filed an appeal. I spoke with you directly when you granted my mother and I's protection order that day.
That's not an
And I
appeal,
noticed-
sir.
Well,
That was a different matter based on different
Exactly.
facts.
And I brought up that particular matter, Your
I know,
Honor.
and I told you I can't hear it because it wasn't in front of me.
You said you would check your calendar and maybe have the opportunity to hear it, Your Honor. That is on the record.
No, no, sir. What you asked me was, you said, I sure hope that you're going to be hearing the appeal that I've got that later on this week. And I said to you, if it's a motion to reconsider, I won't be hearing it. If it's a fresh matter or a different matter, maybe it's on my calendar, maybe it isn't. I in no way, shape, or form indicated to you that I was willing to, because we don't do appeals that way, Mr. Epic. What we do here is we do decisions, they're granted, they're not granted, and if you wish to appeal it, you appeal it to the Superior Court of Whatcom County by following the rules and following the procedures and following all of the things that go along with it. And I know that you know what they are because you presented to me before, and you know the rules, and you're very interested in them. And
So can I
not really.
speak
We're
up?
not. We're
So
not.
the civil-
No,
there was
we're
a
not.
civil-
We're not here to justify your behavior.
My behavior
we're
was
here.
correct. The
Your behavior
civil
was.
request form by Commissioner was not completely filled out, Your Honor.
That is not. The way that you reacted was not proper. That's what I'm trying to tell you. It was not within the rules.
So if I'm violated, Your Honor, you're saying I cannot.
No,
put
I'm
those
saying,
violations out
Mr.
on the record
Mr.
in
Epic, what I'm
regards to the
saying,
case?
what I'm saying is if you have a grievance, follow the rules in the appeal procedure. Do not start filing inappropriate information,
There's
and
nothing, everything has been truthful and in honor.
it's not about truth. It's about
And
what you can
proof.
file and what you need to file in support of your appeal.
Okay,
Okay.
well then, so you're saying I should just refile and do an appeal against the prejudice?
I'm not
And
giving you
acts
legal
against the
advice. What I'm
commission.
telling you is if you hope to achieve your goal, and it sounds to me what your goal is, you want to appeal the decisions, some of the decisions that the commissioner made. Now, what I do know is that you asked him to reconsider a decision, and that reconsideration was done. And then the next step would be to file a formal appeal.
I did
That's-
that, and then the commissioner overseen that matter, which I
But he
requested
didn't.
that he did not, yes.
You did not file an appeal if he denied it. You don't file appeals with
He
him.
wasn't supposed to oversee that matter, Your Honor.
You filed
And
a
that
mo-
is on the record.
You filed a motion to reconsider.
No,
That's how it was
I filed a
changed.
motion to vacate that particular order, Your Honor.
So, okay.
And then he presided over that same exact case and every other case, which his
And
daughter
that's-
confronted me, and she is a direct conflict of
All right.
interest, Your Honor.
Mr. Epic, you're either gonna listen to me
I'm
and
listening
follow
to
the
you, I'm
rules,
just
or you're gonna sit here and argue with me.
I'm not arguing with you,
You
Your
are.
Honor.
You are arguing with me.
I'm-
You're telling me what you did and you're justifying what you
And I
did.
have the material facts to prove it, Your Honor.
Are you still gonna sit here and tell me you're not arguing with me, or are you gonna listen and then we're gonna be done, okay? You did not file what you think you filed. If you want to make the challenges that you made, consult the local rules, consult the appeal rules. If you're in time, file it properly. If you're out of time, you're out of time. If you're out of time, don't continue to file the things that you're filing. It's inappropriate. I think any further filings very well might be referred to the prosecutor's office and very well might be looked at as intimidation of a judicial officer. That's all I'm trying to tell you, okay?
Well, having
Whether
an
you
officer-
whether you did it right or didn't do it right, and I know where you're headed. Officers wander to the courthouse for security purposes all the time, and I know that you felt that there was a case that was prejudged. I saw that in some of your pleadings because an officer was there. That's not an indication of prejudging. All right? So, I've reviewed your pleadings. I'm going to tell you one last time. What you're trying to achieve, you did not file the right paperwork for. And if you persist in filing the incorrect paperwork and not following the rules, you might find yourself in some legal trouble, okay? You're a member of this community. You have access to this. When you follow the rules, you know that things, when the evidence is there, they get granted. If you've got grievances with them not getting granted, then you got to consult the appeal rules and the procedure that needs to be followed.
So you
Do
haven't
not
had-
file information about judicial officers' personal lives, family members, or things of that nature. I would say ever, but it's not relevant. So, that was the goal of what I wanted to have here today, sir. I just wanted to put you on notice as to what you were filing. I wanted to satisfy this issue first. You're good there. You know that you know he has receipt of the order. You know that there's no weapons to surrender. So I hope that you feel secure in the fact that you've got that order. As far as the other things which brought my attention to them, I'm simply telling you, do it right.
So you were able to review the material facts in regards to
No,
that case?
I
Did
was
you
not
say you
able
were
to review
forced
the material facts. I was able to review some of the pleadings and the allegations that you filed because I was trying to figure out why someone would ever file the things that you filed, quite frankly.
Did you see the video
No,
of the court proceeding with
no,
the commissioner?
no, I did not review the case substantially. That is things for an appeal. I am not an appeal court for my judicial officers that are here with me. That's a difference between Superior Court and District Court. I know in Superior Court, commissioner decisions and civil protection matters can be reviewed by a judicial officer. That's not the way it works here. What you need to do is follow the chain of command, if you will, and appeal Commissioner Parise's decisions to the Superior Court. That is who you file all of your appeals with. You don't file them with the DOJ, you don't file them with Cedro Willie, or you don't file them with this court or with me as presiding. You file your appeal and the appropriate paperwork for that with Whatcom County Superior Court.
And I had done that, Your Honor, and then he did not mail the civil request form and scratched out judge, and there was all kinds of findings that were done not in my favor. I simply contacted those agencies because that's what you do
I'm
when
gonna
you
tell you
have
something right now.
violations.
You may very well want to stop talking right now. It's protecting you to not be on the record and telling me all of the things that you did. I've been trying to go about this by talking theoretically, out of respect for you and your rights. But this is the last time I'm going to turn the record off, and we're going to go off right now. You did not file your appeal, if that's what your intent was
Is it
properly.
solely off the record, Your Honor?
No, we're on the record right now, and the last thing we're gonna say is you didn't do it right, go back and do it right, and in the future, you should not be filing information about a judicial officer's personal life in any way, shape, or form. If you have a problem, or if you think that there
And
is,
a judicial officer should not
you're still
preside
interrupting me,
over-
Mr. Epic.
should
Come
not
on,
preside if he's
come
a
on,
third
we've
party,
had,
a
we've
conflict
had.
of interest.
All right, we're off the record. You keep talking and I might find you in contempt, so we're just gonna be done right now. I think I've achieved what I wanted to achieve. You're on notice, Mr. Epic, just do it the right way, and if you refuse to do it the right way, I guess for lack of a better word, you were warned. In terms of what legal consequences could befall you. We're off the record.